We are up to our speaker. So let me come out of here and stop sharing my screen. And I'm going to turn this over to Tom, and he is going to do the introductions for us today.
Thanks very much, Mary Kay. I want to explain to you what this new fashion statement is that I've got here. I told one of our granddaughters this thing I have here is latest and greatest in Champaign, and everybody's wearing them. And she looked at me and said, "Grandpa." So I had a bloody nose, and I have what's called a rhino rocket, which I get to wear until Monday. But that's all explanation for the nonsense I got going. Let me introduce Jason. It's my great pleasure to introduce to you my colleague, Jason Mazzone. Jason is Albert E. Jenner Jr. Professor of Law at the University of Illinois College of Law and Director of the Illinois Program in Constitutional Theory and History and Law. He is one of the leading experts in the country in constitutional law and history and in intellectual property law. His publications in those fields have appeared in the leading law reviews in the United States and abroad. He regularly advises on a pro bono basis litigants before the United States Supreme Court and elsewhere. Jason received his undergraduate and law degrees at Harvard University. While an undergraduate, he worked with the political scientist Robert Putnam on the path-breaking book, Bowling Alone. Jason also holds a master's degree from Stanford and a master's and doctorate in law from Yale. Very happily for us, Jason joined the College of Law in 2012. In addition to being an accomplished scholar, he's one of the most helpful and enjoyable colleagues one could ever hope to have. So please join me in welcoming Jason Mazzone.
Thank you so much for having me, and thank you, Tom, for that kind introduction. I barely recognize myself in that. So it's a pleasure to be here, and I don't usually do PowerPoints, but since we're talking about the First Amendment, I wanted at least to make sure we have the text for just a little bit while I say some introductory things about it. So so here we go. Let's see if this works. I think it will. So we can start with the slideshow. All right. So this is the text of the First Amendment. It's probably familiar in some respects. So I want to say a few things about it. There's actually a lot you can learn about the First Amendment by focusing on the text of it. So it says Congress shall make no law. And it says Congress because when the First Amendment is added to the Constitution in 1791 as part of a package of amendments, the first 10, we refer to them today as the Bill of Rights, these amendments only apply to the federal government. They had no application to state governments. So it's only a limit on the federal government at the outset. That's not true today. Most of the rights that are protected by the Bill of Rights apply equally against state and local governments. So most obviously the protection in the Fourth Amendment, say against unreasonable searches and seizures, constrains both the federal government and state and local government actors, which is why police are limited in their ability to search you or to make an arrest. We get to rights protected by the First Amendment and other provisions of the Bill of Rights applying also to states and local government after the 14th Amendment is added to the Constitution. So this is the 14th Amendment added effective 1868. Section 1 of it imposes restrictions on the states. No state shall, this provision. And the Supreme Court, after ratification of the 14th Amendment, reads this language to include, or we say incorporate, rights protected by the Bill of Rights. And so this process of incorporation begins at the end of the 19th century and continues on today, with the court having now held that most of the rights in the Bill of Rights also apply to state and local government. They're not everything, but all provisions of the First Amendment do apply across the board. The First Amendment also says make no law And so Congress shall make no law refers to the legislature, but courts understand it to apply to all branches of government, not just the legislative branch. So it applies most obviously to the executive branch at the federal level, and also to officials who work for state and local government. So in other words, we read this make no law provision now to mean make no law and enforce no law, or apply no law either. So then let's go back to the text. And within the First Amendment, there's this group of things that are protected. So religion, speech, press, assembly, petition. We look at these things today, and we tend to think of the relationship among them in terms of beliefs and expressions, or religious beliefs and expression through speech or the media. Assembly is what you're doing right now, getting together with others to form viewpoints and communicate them together. And petitioning, complaining to the government. We like to do that. So these all seem interrelated, protecting private and public expression. But that's actually a modern idea. These were actually grouped together in 1791 in the First Amendment because of this, the Congress shall make no law language. So as to these things, the First Amendment says that while Congress has powers listed in the Constitution, including notably here, Article 1, Section 8 of the Constitution, Congress shall have power to do various kinds of things, including to make laws enforcing other powers that it has. It shall make no law concerning these issues that are identified in the First Amendment. So First Amendment starts out not so much as an individual rights provision, but as a federalism provision, meaning Congress shall make no law, so that the power to make law on these things is with the states. And the clearest example of this is the first thing in the First Amendment: no law respecting an establishment of religion. Respecting means concerning. So Congress cannot establish a religion itself, can't establish a national religion for us, but it also could not at the outset interfere with state religious establishments. So states could sponsor churches without Congress interfering, without Congress making a law respecting those state establishments of religion. Today we think about these provisions more in terms of individual rights than about drawing a line between the federal government and the states. But you only get to that point with what I just described, this incorporation of the provisions of the First Amendment against the states. With that, courts understand the provisions to sound more in individual liberty than in federalism. And so the Establishment Clause is first thing in the First Amendment. Once it is applied to the states through the 14th Amendment, it gets transformed. So it means no government sponsorship of or preference for religion. States also can no longer sponsor churches or give preferences to some faiths or to some religions in general. We also tend today to think about the importance of the First Amendment for protecting minorities against the majority, so protecting those who are disfavored, have disfavored viewpoints. So if you think about freedom of speech, for example, what likely comes to mind is ensuring that if you have an unpopular view, they were able to express it, that you're not going to get punished by the majority. But that's also a modern idea, and it only comes after Reconstruction and the addition of the 14th Amendment. The First Amendment, as with the other provisions of the Bill of Rights, starts out as majoritarian, so protecting the ability of majorities at the state level to do what they want. The First Amendment is not at the outset about protecting sort of disfavored, unpopular minority. States are free in 1791 just to ignore minority interests. And so again, back to the text, you see it's the, if you look at the First Amendment, it's the right of the people at the end here, peaceably to assemble and to petition the government. So the right of the people, that's the majority. This is a protection against federal interference with the majority assembly. And then another historical note, We often hear that the rights in the First Amendment are the most important rights because they come first, after all, in the Bill of Rights. There they are in the First Amendment. If you're watching the second impeachment trial, it's a kind of annual event now, as you may have noticed. If you're watching the second impeachment trial, President Trump's lawyers said this, defending his January 6th speech. They said, there's a reason that the First Amendment, the freedom of speech is in the First Amendment. It's the most important of all of the first 10 amendments to the Constitution. But our First Amendment is actually the founders' third amendment. So there were originally 12, this is them, I'll zoom in a second, amendments that Congress approved and proposed to the states. The first two were not ratified, and so their third became our first. So this was the original sequence. The first two are not ratified, they're not approved, and the First Amendment then, which started out as the third, becomes the First Amendment. If you're wondering what those first two were, the original First Amendment, the Founders' First Amendment, was a kind of curious provision that pretty quickly didn't make any sense. It would have capped the number of individuals that each member of Congress represented at 50,000. So you'd keep adding members in the House. So nobody had more than 50,000 members to represent. You start doing the math, and today that would mean 6,000 individuals in the House of Representatives. Even at the time, people say this doesn't quite make any sense. It's going to get pretty big pretty quickly. And the original Second Amendment, our Second Amendment, of course, protects the right to bear arms, but the Founders' Second Amendment ended up actually as our 27th Amendment. It was just hanging around until enough states pushed it over the line with the vote of Michigan in 1992. What it requires, and it's right there in this 27th Amendment today, requires an intervening election before a congressional pay hike can take effect. Tom's an economist; he can tell you why that would be a good idea. So our First Amendment, was the Founders' Third Amendment. There's lots of historical references to the third article of amendment because that's how it was understood when it started out and for a long time. Okay, so I'm going to get out of PowerPoint in just a second. I want to focus the remainder of my comments on this provision of the First Amendment, the speech clause of the First Amendment. It's what many people think of today when they're thinking about the First Amendment. So I want to say a few things about that. So among the various provisions of the First Amendment, we often think about freedom of speech as being especially important today. It's the provision of the First Amendment that people tend to be able to cite, to remember. But as a historical matter, the speech clause was probably the least important to the founding generation. Religious freedom, freedom of the press, rights of assembly and petition were viewed as more important to protect from federal interference. Remember, that's what the First Amendment is doing at the outset. Freedom of speech is there, but as a sort of afterthought and did not have the significance we attach to it today. It certainly didn't correspond to the very robust rights of expression we derive from the First Amendment and didn't have the cultural significance that is attached today to freedom of speech. So it's taken on over time a much greater significance. And so I want to distinguish between two things that are probably obvious, but it's worth saying, and that's between private regulation and government regulation. We often talk very broadly about rights of free speech in ways that go beyond or distinct from what the First Amendment is about. So there are notions of free speech in private settings, in settings that involve private regulation rather than government regulation. And in those private settings, there's a lot of variation as to how much speech occurs and on what topics and how much regulation of speech there is. And there might be punishment even for violating the rules or expectations. So if you think about if you work in a private corporation, there are typically lots of rules imposed upon you as an employee about what you can say in the workplace, and you'd be fired if you disobey. Among groups of friends, there are often shared understandings about how conversations occur, and if you violate the norms, you might not be friends with those people anymore. at the Thanksgiving table, the rule might be we don't talk politics, and if you do, you're not invited back next time. And in Rotary meetings, I'm sure there are rules and norms and consequences, which is for the moment why I get to talk and you're politely listening. That's all private regulation. In those settings, there are often ideas about speech that reflect First Amendment principles, but the First Amendment itself does not apply. On the other hand, there is freedom of speech that is a right protected under the First Amendment, a legal right held against the government. It limits the ability of the government to regulate or punish speech. And the basic idea of the speech clause of the First Amendment, at least as understood today, is that even if speech is wrong or adds nothing or is offensive and divisive or just crazy, the remedy is more speech, not government interference with speech. And if you look at court decisions, the courts talk about a marketplace of ideas in which good ideas compete with and then win out over bad ideas, and the government is not supposed to interfere. The First Amendment, though, is not it's not absolute. There are some narrow categories of speech that courts say they fall outside of the First Amendment. So defamation, for example, is outside of the First Amendment. If I start spreading lies about Tom that damage his sterling reputation, he can sue me, and I can't claim, well, I was engaged in free speech, so you can't punish me for that. Threats that are directed at particular individuals are also outside of the First Amendment. If I call you in the middle of the night and say I'm going to hurt you, the First Amendment is no shield to prosecution. And even with respect to speech that is protected, the government has some ability to regulate. So for one thing, the government can regulate what we call the time, place, and manner under which speech occurs. So for example, by having a schedule to accommodate different groups that want to hold a rally in a public park, you can't all be there at the same time probably. And so the government is allowed to have that sort of schedule. The place where speech occurs also matters for the scope of permissible governmental regulation. The government does not have to open up all of its property or channels or platforms to allow everyone to speak. So there's no general right, for example, to make a speech on the floor of the legislature. In our classrooms here at the university, we can require students to listen without interrupting, and we can constrain the scope of the conversation. Even though we're a public university, we are bound by the First Amendment, and we obviously are operating on governmental property. So the government is allowed and to regulate in certain ways, and it does. But in all of this, there is one important limit, and that is a ban on the government regulating on the basis of the viewpoint of the speaker. So a regulation that treats one viewpoint on an issue differently from other viewpoints on the same issue is almost always invalid. For example, the government could probably say no assemblies or picketing within 50 feet of the entrance to the government building. We have to keep the entry clear. But the government cannot say you can be there if you support higher taxes, but not if you oppose them. So that's a viewpoint-based limitation. The government can stop everyone from being there, but it can't make that further distinction between those who hold one view on an issue and those who hold another. The government at the same time, though, is permitted to open up some property for certain designated purposes or for certain speakers, but not others, so long as it's not drawing that further distinction based upon viewpoint. So it can, for example, provide a forum for a discussion of a single subject, say discussion of the Constitution. So if you want to talk about baseball, you're not allowed to use the forum. That sort of distinction is fine. But if the government were to say, only Republican views on the Constitution allowed here and not the views of Democrats, that further viewpoint distinction would be a problem. So this leads me to the next point. There's a lot of talk these days about hate speech. So many people imagine that that's illegal, right? Illegal to engage in hate speech. But that's actually wrong. There's no category of speech called hate speech or offensive speech that's somehow not protected by the First Amendment. The First Amendment protects all sorts of hateful and offensive speech, and many of the landmark cases from the courts, giving us a sort of modern version of the First Amendment, involve individuals who are at least unpopular and often offensive to many listeners. Government punishment of hateful speech would be a viewpoint-based regulation, the one thing government can almost never do. So my university, public university, could not have a policy that punishes students for expressing hateful or offensive views. That would be a viewpoint regulation of student speech, and it's unconstitutional. There's a lot of confusion about this, though. So our undergraduate student council recently asked me to speak at an event that they called Free Speech versus Hate Speech, Free Speech versus Hate Speech. Now, luckily, I was the first speaker, and so the first thing I said was, no, your title's all wrong. There's no verses, at least as a First Amendment matter. Okay, just a few other points. The Constitution protects the freedom of speech, but free speech is not necessarily free. There are often costs. There might be costs to the listener, has to hear you, might be the target of what you say. People are often disturbed, anguished by speech that they hear. There might also be costs to the speaker. So even if the government cannot regulate or punish the speech, it might be costly to engage in the speech. If you say everything you have a right to say, you might quickly lose friends or ruin your reputation, or if you're running for public office, lose the election, or if you're working for a private entity, be fired by the owner who doesn't like what you say, or find yourself kicked off Twitter. And reputational effects can be especially severe in the internet age, where what you say can be captured and preserved and spread all over the world. So the fact that you have a right to say something under the First Amendment doesn't necessarily make it wise to say it, given the cost that might be attached. Is this good or bad? Do we want people to censor themselves? It probably depends on the setting. In the public university where I teach, there's no question that there are norms that act as a pressure to self-censor. There's value to that in the university. We debate controversial ideas, but there are very few arguments that become stronger in a university because the speaker delivers them in an offensive manner. And we do have to work and study together over over the long term. On the other hand, the risk of causing offense can undermine a robust exchange of ideas if people censor themselves too much. And this then is a sort of constant tension, even when the government itself is not regulating. Speech can also be costly because it can take resources to speak or to speak effectively. If you want to put your views on a billboard for everyone to see, you have to pay. The First Amendment restricts the government, but it doesn't require the government to help you speak. And if others just have more private resources, then that's of no concern to the First Amendment. Government has to get out of your way, but it doesn't have to help you speak. And then the First Amendment protects speech in all of its forms, or most of its forms, but it doesn't protect things that are not speech, but that could nonetheless help you make a point. Violence, physical violence, is not protected at all by the First Amendment, even if it brings attention to your cause. Likewise, creating obstructions to prevent others from speaking is not protected by the First Amendment. Civil disobedience is what lands you in jail. And you can't invoke the First Amendment to tie up traffic or occupy a government building or converge on somebody's house or a business. We have a Supreme Court that is especially bullish on the First Amendment and not just the speech clause. It regularly hears cases involving First Amendment claims, presenting new issues around familiar themes. So just this term, the court's current term, it has on its docket at least 3 First Amendment cases. One case involves whether the California Attorney General can require charities to disclose the names and addresses of their major donors who'd rather have their identities kept private. People sometimes want to be involved in causes without the whole world knowing, and the California AG says this information has to be released, and there's a First Amendment challenge to that. There's a case out of Philadelphia involving the issue of whether the city of Philadelphia's refusal to renew a contract with a Catholic foster care agency on the ground that the agency will not consider married same-sex couples for placement of children in its care. The claim is whether that violates the religion clauses of the First Amendment. Can the city of Philadelphia require the Catholic Church to include same-sex couples as candidates for children? And then the third case that I saw is a case asking whether a public high school, which under existing case law is able to limit student speech that disrupts the operations of the school, whether it can punish a student for things that she posted about the school on social media. She was complaining in vigorous terms, let's say, about not being picked for the varsity cheerleading squad, and the school wants to discipline her for what she said. But the speech is after hours, it's off campus, even though it's shared with many members of the school. How does that matter for purposes of the First Amendment? So lots of, sort of stuff here, and the courts, continue to engage with First Amendment issues every year. There's a set of new cases that the Supreme Court hears and decides, and of course, lower courts as well. So I think I'll stop and see if I can answer questions, or if there are comments, I'd be delighted to hear from you all.
Yeah, Jason, I've got a question. With what we saw on January 6th with the election thing, and all the speakers that got up and, incited incited this riot. And, they're all saying, well, it was our freedom of speech rights. And that battle looks like it's going to be enjoined here pretty strongly. How far can they go before and how does a court decide, okay, this was really hateful, but well, this guy wasn't so much?
Good. So it's a really good question. So there are laws that punish incitement, and so there are individuals who are potentially subject to criminal prosecution with respect to the January 6th events. Certainly people who entered the Capitol can be punished. That's trespassing, acts of violence, all of that. That's not speech, so all of that is subject to criminal prosecution, and those individuals are already being found and identified and charged and prosecuted. Now, with respect to the president's speech, or if we put somebody else in his position, and the question is, how about the person who makes a speech and then afterwards there are individuals who maybe hearing that speech are encouraged to or invited to storm the Capitol or commit other acts of violence? So that falls under the question of the permissible scope of incitement prosecution. So you yourself didn't engage in the violence, but the claim is you encouraged others, and they listened to you, and then engaged in violence themselves. It's actually very hard to prosecute somebody on the basis of a speech on the claim that that speech incited violence. So courts have struck down many of those statutes that allow for prosecution on that theory. Courts have invalidated many prosecutions. Government very rarely brings an incitement prosecution against somebody whose only involvement was speaking. And the courts insist that there be a very tight connection between what was said and violence that actually occurred. So there has to be imminence, meaning that the person spoke and the crowd listened, and the crowd immediately engaged in violence, and that the violence was the result of, caused by the speech that occurred. It's very hard to demonstrate that kind of connection, especially, for example, and I think this is probably almost certainly true of the January 6th speech by the president. You have individuals who have already decided that they're going to come to Washington and engage in acts of violence. The fact that the president may have said something that they understood as encouragement or endorsement or affirmation of what they had already planned is not going to be enough to bring a prosecution on the basis of the speech, because courts view the First Amendment as a sharp restriction unless you can demonstrate, unless the government is able to demonstrate in a criminal case that the speech itself was the cause of the violence, and the violence happened immediately. And I think That would be very difficult. It's very difficult to prove generally, and it's probably very difficult to prove with respect to the president's speech on January 6th. But certainly, as to those who actually engaged in the violence, there's no question that there's no First Amendment protection for that. Does that answer your question? You can certainly.
Yeah, yeah. I got one more attached to that. Let's say a police officer, one of the police officers that was injured during the riot, decided to file a lawsuit based on that. Do the same standards apply through a lawsuit compared to trying to file criminal charges?
I think so. So as a legal matter, it's usually harder to prevail in a criminal case because there are requirements of proof beyond reasonable doubt. Whereas in a civil context, it's usually a lower standard. You can usually more easily prevail in civil litigation. But the First Amendment is going to apply in exactly the same way. So if the First Amendment blocks the criminal prosecution, it's going to block any ability of a court or a jury to impose monetary damages against the speaker on the same set of facts, because that too is a sort of punishment or interference or deterrence to speech. And so it's going to be exactly the same approach.
Okay. Cool.
I have a couple of questions. One is that obviously, I think the big issue has come up with the social media and whether or not the provider of that media, Facebook or Twitter or whomever, is able to stop speech or block speech, which has become a fairly big issue. I'm not sure how that applies. And the other thing is, you mentioned, I think early, that the First Amendment, I'm not sure that the founders actually, were they actually trying to say there's a hierarchy in the Bill of Rights? Or is it just that that's where those things fell? You know, whether you call it the First Amendment or the 24th, I'm not sure that they hold any more value than the other.
Good. Let me take the second one first. And I think your suggestion is actually absolutely right. The sort of order is not a hierarchy. I mean, it's reflective of when things are added to the Constitution. But even within the first 10 amendments, it's not as though what was first was the most important. The order actually tracks the provision of the Constitution that is being amended. So when Madison proposes the first set of amendments, the first 10 changes, first 12, I'm sorry, changes to the Constitution, they're not actually proposed by Madison as an addition. So they're not tacked onto the end of the Constitution in the way that we see amendments today. So what Madison wanted to do was to go into the original document and insert the amendments into the existing articles where they matched up. And so that Congress shall make no law provision would have been inserted into Article 1, where there are powers for Congress to make law. So this is Madison's idea that that's what it's referring to. So that's where you put it. And so it's only at the last minute in Congress that there's a view that, maybe we shouldn't mess with this thing, this original document. And so let's add everything to the end as sort of freestanding provisions attached to the end of the document. It's a last minute change that is made. And so the sort of hierarchy idea would be wrong because it's really a kind of product of that historical shift that occurred very late in the process. With respect to the social media issue, it's a really important issue because, of course, this is a context in which many people, especially these days, speak. Right, this is the forum in which many people express their views. The First Amendment does not apply. There is no application of the First Amendment to Facebook or Twitter or Google. Those are private entities. They are not bound by the First Amendment, and they don't tend to adhere to First Amendment norms either. So Facebook and Twitter, they have rules about what you can say, and if this is why the president is kicked off, right? But they have broader rules than that, and the rules seem to change a bit and to be even more robust now than they were even 6 months ago. So their offensive speech or hateful speech or racist speech, you can be kicked off the site on the basis of that. The government could not do that, but Facebook, Twitter, these are private corporations, and they can impose all those sorts of restrictions upon you. And if you scroll through and read carefully the terms of service that you agreed to when you joined these sites, and of course nobody reads all the fine print,
That's right.
written right in there, you agree. Bound by all those kinds of restrictions and any additional restrictions that the company adopts in the future. So if you violate those terms, there's no question that you can be removed from the site. Even though, of course, today it can have a huge impact on your ability to speak. And of course, we saw this with respect to President Trump. I mean, just this silence from Trump after he's removed from Twitter. Which was the primary way in which he reached his audience. But these are private entities; it's not the government.
Kind of a follow-up question to social media. As a journalist for the past 50 years, we were always very careful as to where the line of libel and defamation was, and we were held accountable by, as a print journalist. But people who post in social media, there doesn't seem to be any moderating force of libel action or anything like that. Why is that?
Great. This is a great question. So the print media, as the publisher, if you disseminate something that is a falsehood and damages somebody's reputation, as you said, Daryl, you can be the publisher can be sued, and typically it's the publisher that someone who is injured will go after, because it's typically the publisher who has more money, and so you sue the New York Times for even if it's an op-ed that somebody has written, because the New York Times is the publisher and there's liability allowed against the publisher, because the New York Times will have deeper pockets. But you're quite right. If somebody posts something, the same kind of thing, on the internet, on a website or a blog or Facebook or Twitter, you cannot sue the platform. You can't sue Facebook for things that its users post, however defamatory. You could sue the individual user, but you can't sue the company behind it. And the reason for that is not the First Amendment. It's because Congress, back when the internet was sort of getting up and running in the early 1990s, enacted a statute, and it's called Section 230 of the Communications Decency Act. And under this provision, Congress said no lawsuits against service providers, websites, blogs, the operators of internet services or platforms for the content that is posted by others. And the reason Congress did this was that it was very concerned that no one's going to set up something like Facebook or Twitter or blogs or get the internet up and running in the way that Congress wanted, if all of those investors and corporations were going to be liable for every single thing that the users posted. And you could imagine that this could be problematic today. If somebody posts something on Twitter and Twitter is liable in a defamation suit or a copyright violation, it's going to be difficult for Twitter to operate in the way that it does. And so Congress, as a statutory matter, gave a shield to all of these internet providers and platforms from being held accountable for anything that their users post. Some people today think, we should take another look at this Section 230. Congress should amend it and allow for liability in some circumstances. The result, because the internet is up and running, and so you don't have to worry so much about those sort of startup costs anymore. The end result, as you suggested, Daryl, would be moderation by the entities themselves. They do some of this on their own because they want to. But if you were to hold them liable, accountable for things that their users posted, then they would have to look much more carefully at what is actually being posted. Whether they'd have to have a pre-approval process, or you can imagine even a system. This has been pitched to Congress that they have maybe 24 hours after receiving notice that there's a problem to remove something, and then after that, if they don't take it down, they can be held accountable. So there would be sort of ways of addressing this without just the sort of complete liability that applies to any print publication. The internet companies, of course, don't like any of this at all. They don't want to be in the business of checking what people are saying, because if they don't take it down or address it, or if they have to pre-approve everything, then that's really bad business from their perspective.
I would love to continue. I'm sorry. I'd love to continue this conversation. And if I could, I'd like to go ahead and close the meeting. And could I keep you around for a few more minutes? Because I've got a feeling there's more questions out there. But for folks that need to get away, let me go ahead and close the meeting, and we'll come right back. How does that sound? Can we give them a big hand before we do that? Awesome. Thank you. All right. Let me go ahead and close off this meeting real quick. Well, maybe I will close it off real quick.
Oh, that's good. Where's that?
This is actually in gosh, I don't even remember anymore.
It's Mediterranean.
It was the Mediterranean. Yeah, it was where Prince Rainier lives and all that kind of good stuff.
That's me sitting on the bench there.
Well, it isn't.
Monaco?
Okay, I guess we're not sharing. So I wanted to tell you, next week, Jared has agreed to be our speaker for April 1st. He is going to do some cool stuff about Champaign Park District and Illinois parks in general.
Yay.
So definitely check back with us for that. And Charlie, would you do the 4-way test for me?
Is it the truth? Is it fair to all concerned? Will it build goodwill and better friendship? Will it be beneficial to all concerned? And our 5th, is it fun?
Thank you, Rotarians. Okay, now we can get back to the questions.
Okay, Jason, I do have a question. I want to make a comparison to the president's speech and what he said then. Let's say I'm planning to rob a bank with several friends of mine, and we go there and I'm in the car. I say to them, go inside and do the job. And they still rob the bank. They kill somebody in there. They come back. Now, what the president said was, and I can't remember the exact words, but he said, I'm going to go there with you. Doesn't that make any sense to go after him for that sentence that he used?
I mean, so the claim, I'm going to go there, I'm going to march with you, right?
Right. That's what he said.
Yeah, I mean, so you have to ask, is that an instigation of the riot, right? Is that the thing that persuades individuals who would otherwise not be inclined to engage in violence to do it? Maybe you'd run it by a jury and ask whether they think there's a tight enough connection. I suspect courts would be very suspicious of any liability given.
And the reason that I said that was, as soon as he said that, people started moving towards the Capitol.
Yeah, people may have started moving. The question is, if he hadn't said that, would they have still, at the end of the speech, descended on the Capitol? And I think, I think the evidence suggests that they were there, they were fired up, there were already people who were at the Capitol ready to go. And so I think, this is how courts would look at it. And I mean, you're right, it's a kind of disturbing speech when you listen to it.
Sure was.
But I think nonetheless that courts are very wary about reading a statement of the kind that you mentioned as an incitement of an insurrection, because they're concerned about the sort of chilling effect that would have upon other speakers. The bank case is much easier. That's a conspiracy, and there would be an immediacy to that. And actually, I mean, if you did it as described, there's this rule called the felony murder rule. So if someone dies during the course of a felony, which you are now part of, even if you're actually just sitting in the car, you never pulled the trigger or anything, never even entered the bank, but you're actually part of the operation, you're actually subject to prosecution for murder. And First Amendment will be no defense to that. You can't say, oh no, I was just sitting in the car, and yes, I said go in and rob the bank. So there, I think courts would have no problem finding a First Amendment. Finding the First Amendment does not apply, and for another reason as well, there's a political dimension to President Trump's speech on January 6th that is not true in the context of the bank scheme that you described. And political speech receives the strongest possible protection under the First Amendment. And so sort of even if the facts were roughly similar, you might still say that the president's speech is nonetheless protected because of the importance of making sure that political speeches are not subject to sort of a lower level of protection than say the bank robbery related speech.
Yeah, unfortunately, the end result was pretty much the same because we had 6 people who died and all kinds of damages and everything.
Right, and so a court, I think, would say yes, and the individuals who committed the acts of violence are responsible for those deaths. But you can't pin it on the political speech by the president without something more.
So the little guys are going to be punished, but the head is not going to be punished.
It seems always the case.
Yeah.
Jason, I have a question. My favorite quote is James Madison's, "Knowledge will forever govern ignorance," and I think that that's fundamental in the freedom of speech, freedom of press, because the better freedom, the basis of that whole thing is we have a better government when we have more open communication. My concern is how much our attack on facts are affecting that government. It's like, for example, the lawyer who right now case is saying, well, no one, I told all these lies, but no one had any thought, no one could have possibly believed them because I was just saying them. And it's the whole concept of alternate facts destroys the value of if you can just lie and say whatever you want, then you've destroyed the value of speech helping our democracy, which he says, without that, as Madison says, it's just a travesty. And we have to have knowledge to govern well. And our erosion of what is fact and I have the right to lie in my speech and address that. I mean, that's just to me, that's the most important concern in government right now.
Great. Yeah, I mean, so let me say a couple of things. So in the context that you're talking about, so the claims about the election being stolen, dead people voting, and the voting machines being rigged, and thousands of ballots, being found for Biden, and so on. These were, of course, statements that the former president made repeatedly, allegations that the former president made repeatedly. His supporters brought lawsuits in I think about 80 of them all told, in federal court and in state courts, trying to overturn or contest election results on that basis. And of course, this was the sort of the basis for the January 6th speech. And even while Congress was meeting during that, shortly after or during that speech, you had members of Congress who were making similar kinds of claims. I think you're right that from a sort of perspective of democracy, this idea that there aren't really any facts, that facts are just sort of in the mind of the beholder, and that they're sort of alternative facts and alternative realities and so on.
We can create our own facts.
Yeah, this I think is a problem, especially when you're talking about the outcome of an election. Even today, there are large numbers of people, something like half the country, believes that the election was stolen, and that's not a healthy thing in a democracy. The one thing I will say was that I was very proud to be a lawyer during this period because all of these cases, when they were filed in courts, whether they were state courts or federal courts, whether they were judges appointed by Republican presidents or Democratic presidents, whether they were state judges elected and they were either Republican or Democratic, they found that there was no basis for any of these allegations. So in court, in contrast to making a sort of a political speech, you actually have to back up your allegations with real facts. There's no notion of alternative facts in a judicial system. Judges across the board insist upon a factual showing. And so when these allegations were brought to court, there was an opportunity to back up the claims with evidence. Everything just fell apart, and none of these cases succeeded when facts mattered. And so the judicial system, I thought, was in a way sort of democracy's guardian during that whole process. I started to hear your concern that notwithstanding that, there's still many people who think that there were serious irregularities and cheating, and the president didn't lose the election fairly, notwithstanding the fact that there's just no evidence that that's true. There were evidence. We want to know about it, and courts would certainly be interested in pursuing it. But if you can't, come up with, as you said, the facts, then that's a problem for the judicial system. But the sort of larger democracy question, I think, is.
But those people are not using the judicial system. They're using press. They're using the freedom of the press. They're using freedom of the press and to do it. And I think that's I have no answer. I mean, I worked in broadcasting, advertising for a million years, and the concept of puffery in advertising is one thing, but what about puffery in law and government?
Yeah,
that's a concern.
It's a problem, and of course, you can communicate falsehoods, right, much more effectively and faster now with internet platforms than you could a generation ago. So that is I hear you.
I've got a question on words of the Constitution, because a lot of times specific words are discussed, sometimes in court, what the interpretation was. And if you do your research at the end of the Constitutional Convention, the ideas of the Constitution were handed to, I think it was a committee of detail, which was to organize the Constitution. And then it was handed to a single person, Governor Morris, who wrote the actual words of the Constitution. Is there debate, is there study about what went into that evolution from the ideas all the way down to the individual words, and what subtle changes there might have been, which today we debate endlessly?
Yeah, I mean, so it's a closed process at the outset. So you can't watch it at the time kind of unfolding. It's a secretive process that produces the final text. But there are records that were generated and released afterwards. Most of what we know about the drafting process, unfortunately, comes from James Madison's reports. I say unfortunately because what that means is that he gives himself a sort of starring role in the drafting of the document, even though we know that as you would, right? You get to write the history, and so you emphasize your own role. And so Madison's notes are a source that is used extensively. It's written after the Constitution is ratified, and as I said, sort of recreates the history a bit to emphasize his own significance and influence. But there are others who have generated notes as well, sort of reporting on the process. The approach of the courts is actually not so much on what you described, the sort of drafting process or the sort of transitions from one stage of the process to the next. The courts sometimes pay attention to that. The approach that courts take now when they look historically is to ask something more straightforward, which is to say, what did the words mean to the people who voted in favor of the Constitution at the time they were voting? And so they look to dictionaries and other sources of meaning rather than looking so much to the legislative process. So this sort of approach is the legacy of Antonin Scalia, who pushed this idea of original meaning as the best way to understand the Constitution historically. And all members of the court actually do this to some degree or another today. So I think what you described, Jerry, is it's useful evidence, but it's not the thing that that most constitutional interpreters are focused on today.
Thank you.
Well, and as you can tell, we could keep you going forever here. But we thank you for your time. And we had a very appreciative audience, and we appreciate you coming today.
Well, this was so fun. Thank you.
Oh, great. It was great having you, man.
Thank you.
Great.
Have a good evening, guys.
Take care. Bye-bye.
See y'all.
Bye-bye.
Thanks much.
See you, Robert.
Have a good day.
Everybody. Stay dry. It's going to rain.
Yeah, that's okay.
Hey, Eddie,
That's me.
I'm waiting on a written proposal from Teresa at Logic, but hopefully I'll have it by next board meeting.
Cool.
Yeah.
That'd be great.
Yeah, I they're going to give us the big event room, and I think we'll be able to be in there in June. I think
Oh,
they'll be
yeah.
all ready for us.
Sounds great, man. It's going to be so good.
Awesome. I
See
hope it
y'all.
works out.
And,
See ya.
and she's also excited about maybe trying to get back to another karaoke event next
Yeah,
January.
sure. Why not? By then, by God, it better be all right, or we're all going to be dead. So.
Oh, boy.
See you guys. Bye-bye.
Bye. Have a good one.
That's good. See ya.